Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. Inshallah, today I will present or make a video about the IQRAR. So, the first is the definition of IQRAR. IQRAR means declaration or recognition or admission. In Shafi'i school, IQRAR is informing a right of another by informal against himself. IQRAR is acknowledgement, and IQRAR is referring to something not belonging to a person making it. The legal principle of IQRAR is, first is muqarrun, which is the person who makes such confession. Second, muqarrun lahu, the person in whose favor the confession is made. And the third, muqarran bihi, which is the subject matter of the confession. Here, we state three authority of IQRAR, which is in Surah Al-Qayyimah, verses 14, Al-Baqarah, verse 282, Al-Imran, verse 81. There is 10 condition of the person who making such confession, which is the muqarrun. First is sound mind. Second, attained age of puberty. Free person, free will and consent, healthy, no suspicion, intentionally made. A person who makes an IQRAR must be identified. A person who makes an admissible shall be a person who is not prohibited from administering his property. And lastly is, a person who makes an IQRAR must understand the consequence of his IQRAR. And the condition of muqarrun lahu, which is the condition for a person in whose favor the confession is made. First is, a person in whose favor the IQRAR is made must present at the time of the submission, or still alive at the time, and pass away later. If the person to receive the IQRAR is not exist, as such the IQRAR is null and void. Secondly, the person also must be eligible to accept the aforesaid of IQRAR. If it is not eligible, the IQRAR is null and void. And thirdly, the person in whose favor the admission is made must be identified. If two persons have been granted to receive the IQRAR or certain properties without giving the proportionate between the two persons, it has been considered as null and void. The appointed judge has no power to cancel the IQRAR, but to impose the eligibility of IQRAR. And lastly, the person in whose favor the IQRAR is made must be the person who have a reasonable ground in order to get the subject matter of IQRAR. The condition of muqarrun bihi, which is the condition of the matter which is the subject of IQRAR, is, first, the matter which is the subject of the IQRAR must be known. This requirement is important in order to endure the matter or thing can be claimed by the claimant. And secondly, the term of IQRAR must be said orally by the person who made the IQRAR. For the related case, in this case, the first accused member of parliament was charged with and had pleaded guilty to an offence under section 124 of the Islamic family law. for contracting a polygamous marriage without the consent of the court, while his wife, the second accused herein, which is an artist by profession, was charged with and had likewise pleaded guilty to an offence under section 40 clause 2 of the enactment for contracting a polygamous marriage without the consent of the registrar of Muslim marriage, divorces and rujuk. Additionally, both of them, together with other accused, had also been charged with several counts of abetment to the offences and had pleaded guilty to same. This apart, the third accused, the biological brother of the second accused, had been charged with and pleaded guilty to the offence of acting as a wali and solemnizing the marriage without the consent of the registrar under section 40 clause 1 of the enactment, or the accused having been convicted of the offence charged against them. A question hence arose before the learned subordinated court judge herein as to the appropriate sentence to be imposed upon each of them. The court held that sentencing first accused to 1 month's imprisonment for the offence under section 122 of the enactment, and the other accused to a fine of 1,000, in default 6 months imprisonment for abetment thereof. Sentencing second accused and all other accused to a fine of 1,000, in default 6 months imprisonment for the offence under section 40 clause 2 and the abetment thereof respectively, and sentencing the third accused and the abettors to a fine of 1,000, in default 6 months imprisonment for the offence under section 40 clause 1 of the enactment. Is an admission made by a person in writing or orally or by gesture stating that he is under an obligation or a liability to another person in respect of some right. A IQRAR shall be made in court before a judge or outside court before 2 male witnesses who are akil baligh and the third case is pendakwa syar'i wilayah persekutuan and Siti Nurasniza Kamarudin. In this case, the accused in this case had pleaded guilty to a charge of having sexual intercourse outside of wedlock between the months of January to December 2008 at the Selangor Mansion Flat, Kuala Lumpur, pursuant to section 223 clause 2 Syariah Criminal Offence Act 1997. It was not disputed that as a result thereof, the accused had given birth to a child before the learned judge upon her conviction. The accused pleaded for a reduced sentence as she had already repented and vowed not to repeat the offence. The sole issue that came from determination was as to the appropriate sentence to be meted out, considering in particular the fact that the Act was prescribing a sentence of a fine of not more than 5,000 or imprisonment not exceeding 3 years or whipping not exceeding 6 strokes or any combination of this punishment. In this case, the court held that the accused was aged below 16 years at the material time and was hence a youthful offender under section 2 of the Sharia Criminal Procedure. Under section 128 clause 1 paragraph A and B of the same Act, a youthful offender may be sentenced to a fine or imprisonment as prescribed for the offence. In this case, the accused's plea is a form of IQRAR and is binding on her because, according to Dr. Mahmud Saidun, HAZMAN, in his book Islamic Law of Evidence, published by Dewan Rakyat and Pustaka Kuala Lumpur 1990, when an oath is uttered, it commits and binds those who made the vow in the matter concerned. Also, in Surah An-Nisa verse 135, state that, O you who believe, be maintainers of justice, bearers of witness of Allah's sakes, through it may be against your ourselves. Also, in this case, it is in statutory provision of evidence, namely Section 17, Class 1 and 2 of the Sharia Court of Evidence Act 1997, which this act defined IQRAR and how the IQRAR should be made. And the third case is Muhammad Sufi Abdullah and Ketua Pendakwa Syar'i Selangor. Before the Syariah Subordinate Court, the appellant pleaded guilty to a charge under Section 200 and 123 of the Islamic Family Law, Enactment 2003, for contracting a polygamous marriage without the consent of the court, and upon conviction was sentenced to a fine of 999 in default 5 months jail and 10 days imprisonment. Being dissatisfied particularly with the imprisonment sentence passed, the appellant appealed and argued essentially that since this was his first offence, the imposition of a jail sentence by the trial judge was unwarranted and uncalled for. The issue that arose was whether on the facts and in the circumstances and bearing in mind public policy, the sentence passed was fair and adequate and ought to be affirmed, or whether the same was repugnant to the established principle of sentencing and ought therefore to be disturbed by Sharia High Court. And the court held that upon the provision of Section 124, the power to determine whether sentence that was to be imposed was a fine or imprisonment or both would depend on the discretion of the court. Also, the court would refer to the book Hasyiah Il-Anat Talibin, Part 3 at page 224, thus which means Iqrar from the lingual perspective means to admit, whilst the Shara construes it as acknowledging others' right over oneself. Iqrar is also sometimes called Iktiraf. In the book Mughni al-Muhtaj, Volume 3, at page 267, it was stated, which means the prerequisites of Iqrar are four, namely Muqirrun, Muqarrun, Sighah, and Muqarram bihi. In the Quran, verse 135 of Surah An-Nisa also mentioned about the Iqrar. In this case also state the hadith of Rasulullah sallallahu alaihi wasallam, which Rasulullah had accepted the Iqrar on adultery as made by Ma'iz and Ghamidiyah and had ordered the punishment of had against them both, thereby confirming the validity of proof by Iqrar within Hukum Syara. As for the law, the court would refer to Section 17 of the Sharia Court Evidence Enactment 2003,